Welcome to our February webinar, a collaborative presentation of the Federation for Children with Special Needs and the Recruitment, Training, and Support Center. Today's webinar is 10 Traits of Effective Parents in Special Education, presented by Attorney Jeffrey Sankey, founder of Sankey Law Offices, a general practice litigation firm with a concentration in special education law. Attorney Sankey assists caregivers in the IEP process and works to help families obtain appropriate special education services and placement. Welcome, Jeff.
Thank you.
During the webinar, please type your questions into the toolbox and we will try to answer them during the presentation. Past webinars are archived on our RTSC website, along with many resources on trauma and learning and educational issues that impact the student and child welfare systems.
Clear my screen there. There we go. Good. So good afternoon, everyone. My name is Jeff Sankey, and what I would like to talk to you about this afternoon is a presentation that we put together a couple years ago called 10 Traits of Effective Parents in Special Education. Sort of the genesis of this was very early on. We had a presentation called the 10 Biggest Mistakes that Parents Make in Special Ed, and I think we decided we wanted to do something a little bit more positive. I found that over time in working with parents over the past 10 or 15 years, there really are some traits that I think are very common to parents who seem to have the best success in getting what their kids need. And so that's really the purpose of this presentation, is just to sort of concentrate on those 10 traits that I think will help you as you're working with your kids. I understand, a lot of people out there are parents. Some of you are, what was the term that you used?
Surrogates.
Surrogates working with children. So certainly that you're my intended audience. If you do have questions, please send them in, and I'll try to address them as well. So let's see if we can move the screen. Looks like the screen's locked. Well, while we try to fix that, I'll keep moving on, and then you can follow on as we overcome a little bit of technical difficulty. So I think the common traits. Oops. All right, let's see if that works. There we go. So number one, effective parents are involved in their child's education. Just by virtue of the fact that you've taken the time this afternoon to listen to the seminar tells me that you're probably meeting that requirement. There is, under the federal statute, which is the IDEA, we'll talk about that a little bit this afternoon, it recognizes the importance of parental or adult guardian participation in a child's program. You are a critical member of that team, and it's really important, I think, to be effective advocating for a child, that you have to see yourself as an effective partner with your child's teachers and administrators. The next little bullet on my slide is that you do need to trust your child's teachers, but don't trust them blindly. By that I mean have an expectation that your child's teachers, administrators are working on behalf of your children, and I think 99+% of the time that's absolutely correct. But I think as parents, it's really important to realize that you've got a responsibility to speak for your children and to ensure that the staff members have an understanding of what you're seeing about your children. It really is important for you to be an active participant in team meetings, and you need to contribute and bring to the table things that only you know. You assume that the service providers are qualified and that services are being delivered in compliance with the IEP. So if you have a child, for example, who's supposed to be getting 30 minutes of physical therapy 3 times a week, there's nothing wrong with you asking to make sure that that's happening. If you think your child is supposed to be, getting services from a speech and language therapist, there's nothing wrong with making sure that it is a speech and language therapist and not an assistant that's providing those services. You have to find as many ways as you can to be involved in your child's program above and beyond IEP meetings. It really isn't enough, I don't think, to show up at an IEP meeting once or twice a year. if you have the opportunity to go to the school, to participate in teacher conferences, to anything that you can do to see how your child is doing, I think is going to advance your cause. Number 2, affected parents are aware of their child's disability and strengths and weaknesses. I think the key to this one really is you have to trust your instincts. I can't tell you how many times over the course of a year that we have a parent who comes into our office to talk about a child, for example, that has a reading disability, and basically says, I suspected this in 1st grade and I wasn't sure in 2nd grade, but now my child's in the 5th grade and isn't reading, and I had my child tested, and in fact my child has dyslexia. That's really a parent who has trusted the school, that didn't step in to require that evaluations be done, and it's a child that, again, unfortunately, didn't have the benefit of things that would have happened had the parent been more aggressive. And again, that's not criticism of a parent. You do expect teachers and administrators to step in. They're the experts, but don't underplay. Don't ignore your own instincts. You know your child the best. They see your child 4 or 5 hours a day. You're with your child on the weekends, nights. What you see really does matter. Once you have a child that has a disability that's been diagnosed, that's not enough as well. You have to make sure that when you bring that information to the team, and then you have to continue to advocate to make sure that your child's getting the services that they need, making sure that your child is aware of the IEP services. We all know how much effort goes into the development of an IEP, but an IEP isn't any good if no one reads it. And you have to make sure that when you're meeting with the teacher, that they're aware of the services that your child is supposed to receive, and the concerns that you have, accommodations, things of those nature. To the extent that you can, the 3rd slide is have an understanding of special education rules and regulations. By that, I'm not saying that you need to have a legal background, you don't have to be an advocate, but you need to try to do the best you can to have a fundamental understanding of what your child's special education rights are. That's really recognized. Some of you remember that when you go to a team meeting, you're going to get a handout of the procedural guidelines. That's just not a piece of paper to throw away. Even though I have been doing this for 15 years, I try to make a point of trying to read it myself once or twice a year, just to remind me of how important some of those rights are. So you as a parent, when you get those, take a half hour, take 15 minutes, whatever time you need to go over those rights to make sure that you understand the very important rights that your kids have. Recognize the importance of seeking advice before you make major decisions about your child's education. When you come out of a team meeting and they're proposing that maybe your child's not eligible for services any longer, or a major change in your child's program, or a different placement, those are very significant decisions that have a long-standing impact on your child. And it's really important, if you don't feel like you have the confidence to know exactly what's being proposed and what you should do, to seek out the help of someone who does. And that doesn't mean it has to be a lawyer. It doesn't mean it has to be an advocate. All of the school districts have special education PACs with experienced parents. There are many, many people that are out there that have been in your shoes before that you can reach out to and just get a sense of just a degree of confidence that what's being proposed is right for your child.
I have actually a question that jumps back for a second here on how does a parent or a surrogate parent approach the situation when the school says, well, it's not happening here?
So we hear that too often. So an example being, you have an evaluation that says that your child should be in a language-based classroom, and they say, well, we don't have one. My response to that always is when you think about the word IEP, the first word is individualized. And the individualized means that a school district cannot take a position, we don't have that. A school district under the individualized part of an IEP is supposed to create it, and if they can't create it or they choose not to create it, then they have to send your child somewhere where your child's needs will be met. So I think that, again, that's a phrase you should never hear. but I would be very naive to tell you that you won't hear it. But when you do hear it, that's your response, is that if you don't have it, who does? Because that's critical.
I think that the question comes also based out of a lot of people asking because of behaviors, that they're not seeing the behaviors at school that parents are talking about, or they're not seeing the child struggling with, where they're struggling with homework, but the teachers aren't seeing them struggling with the work in the classroom as well.
So again, that's another common thing, that we do here, that you have, your daughter comes home at the end of the day, she's 14 years old, she's been bullied at school, and when she walks in the front door, she falls apart. Why does she fall apart? Because she's comfortable at home, you're the mom, she has, she can let it all loose with you, but she's not going to let it all loose at school because she doesn't want to be embarrassed. She's going to do everything she can to not show those types of weaknesses, to not show that she's bothered, and it's understandable. But when you take that information to the team, they are going to say to you, we don't see that. And I think it really becomes your job as a parent, number one, to the best that you can, to explain to them, that your child is a whole person. She exists 24 hours a day. You're seeing her for 6 to 7 hour segment, but this is really what's going on. In my experience, that probably won't be enough. Generally what you need to do at that point is that's when you're going to be bringing in people that are on your team. It can be someone as simple as your pediatrician, your child's therapist, if you need to get a neuropsych evaluation, if you need to bring in an observer. And we can talk more about it later on, but one of the critical tools that a parent has available to them, albeit sometimes expensive, but a real critical part of assessing a school district program is bringing in your own observer and having an observer go in and see your child every day. For several hours in the course of a day, excuse me. When you have a child who has an emotional disability, what's the first place that I want the observer to see the kid? I want the observer to go to lunch. Because if the school district is telling you that your child has friends and everything is fine, you have an independent observer who goes in and sees your child sitting at a lunch table by herself, no one speaking to her, being obviously uncomfortable. That tells us a lot about the social skills that your child or the social difficulties that your child may be experiencing. So those are just a couple tools, but I don't go back to my second slide. Just don't accept the fact that the school says everything is okay. It may be okay in their eyes. I'm certainly not suggesting that they're lying to you. What I'm saying is that's what they're seeing, but it doesn't mean that that's the be-all and end-all. Many children go home at the end of the day and tell you really how they're feeling, and you're the only person who can speak for them. Does that sort of address that?
Yes, thank you.
All right, I just passed over the copy of your procedural safeguards. You've all seen that. Number 4, really important, effective parents maintain accurate, complete, and organized records. When I see parents come into my office and they've got a great big box of loose papers, I could cry. It is really important very early in your child's educational journey, particularly if you know that they have a disability and they're going to need some services, to come up with some way of maintaining your records so that you have the ability to put it all together and remember who said what and what services your child received when. A lot of parents come in with 3-ring binders. Those are great. Some parents just have manila folders. Those are great. Whatever it is that you do, there's no right or wrong way, but just make sure that you have some way to organize your child's files. If you go to an advocate, if you go to an attorney, we're certainly going to be asking you questions. What services did your child have 2 years ago? And you're not going to remember, and we understand that you don't remember. But if you have an IEP, we're going to flip right to the grid. We're going to see what's there. We can track what's been going on, with your child. Really important to do that.
How long would you recommend that people keep, Jeffrey is now 17, and do we still need to keep his IEP from when he was in 3rd grade?
I don't think you need it. In terms of, if someone came into my office with a 17-year-old, I probably wouldn't be asking for those records. But on the other hand, if you've done a good job and you've kept them, I would probably keep them in wherever you keep your files, in the drawer or whatever, until he ages out. I really would. because you just never know when someone is going to want that evaluation that maybe, where was he cognitively on his first evaluation, and you've thrown it away. I think if you've gone to all that trouble to keep them, there's no benefit to throwing it away until he ages out.
Okay, great.
So what should go in these records that we're talking about? All correspondence, including any emails with the school relating to your child's performance. Now, I don't mean you have to copy everything that says what time is the field trip tomorrow, but what I'm talking about is anything that relates to your child's progress, your child's program. You certainly want copies of all evaluations, whether done privately or by the school. Signed copies of all IEPs, really important. A lot of times when you get an IEP, you're going to be asked to sign the signature page. You sign it and you send it back. When you come into my office, I'm going to say to you, did you accept that? And you don't remember because you didn't keep a copy of the signed page. So really, the school is going to give you a copy of the IEP. Just make sure that you keep a copy of the signature page, because that really is an important document. All progress reports, test scores, report cards. When you go to a team meeting, hopefully you're taking notes yourself, either at the meeting or immediately after. I definitely would like to see those notes. They're really important. And depending on your child's disability, some samples of your child's work. If your child has dysgraphia, for example, a child who's having difficulty writing, you may want to keep a writing sample to show us just a sense of what's going on.
I actually had recently a question that had come in to the support center, that a parent was wondering whether they should sign an IEP that the school has not signed, or should they send it back, ask for it to be signed first.
Yeah, I would never sign an IEP unless the school has signed it. I mean, the sequence of signatures on an IEP is that the school is supposed to make a proposal to the parent. I can't think of any reason for a school district to ever send an IEP to the parent and asking them to sign it first, because it's almost like a contract. That's what they're proposing, you're accepting it. And so it's really hard to accept something that hasn't been signed off. So I can't think of an exception when I would ever do that.
Okay, great.
Okay. Number 5, effective parents cooperate and share information with their child's teachers and special education team. Really important. I think it's, sometimes when we get into these seminars, we think of special education as being us versus them, and that's not the way that it's supposed to be, and nor is anything that we aspire to. It's called a team meeting. As my first slide was, you're a member of that team. The goal under the IDEA is that all parties are going to be working together for the benefit of the child. Sometimes I have parents who come in to see me and they'll say that they had an evaluation done, but they don't want to share it with the team. And I always think that that's really a bad idea. I can't think of an occasion where I've really told anyone that that's okay. If you've got an evaluation from your own expert and they make recommendations, about your child, that information really does need to be shared with the team, because if you don't, you certainly can't hold the team responsible for making changes or revising your child's program if you haven't shared that information. You certainly, if you move down the road and you come to see me and you tell me that you want to file for a due process hearing, looking for more services or a different placement, one of the first things I'm going to ask you is, have you shared all this information with the team? If you haven't, the only thing that I can tell you to do is to go back and share it, because if I start that process and the school district finds that we haven't disclosed all the information, we come to a grinding halt. We have to go back to another team meeting. They'll get another opportunity to make a proposal for your child. You could lose 6 months to a year in the process, by not sharing the information. It's really important, and frankly, again, it's the right thing to do. This is not intended to be an adversary relationship. If you have information, it really does, need to be shared with your child's teachers and team.
I just have a couple of questions before we move on that kind of goes back to what we were talking about. In the learning-based classroom that you were talking about, what if the school creates a program that only has 2 students in it?
So question being, I used an example a couple minutes ago about a language-based program. So if the school says, okay, we're going to create a program with 2 children, remember that education is not just all academic. There's an emotional, there's a social piece, there's a behavioral piece to every program. So if you have a child who, like any child, needs social interaction, and they're going to be in a pure language-based program with 2 kids, I would certainly be arguing that it's not appropriate. I don't think it would take very much to have an expert or anyone who knows your child to say that your child needs more than one other child to interact with all day long. Mm-hmm. So even though your child may be getting the language-based support that they need, it's being done at the expense of your child's social development. So I don't think a 2-person classroom, I can't think in too many circumstances would ever be appropriate.
Would there be a difference if it also has to do with the number of males versus females in the classroom?
I had that question asked actually with a parent yesterday, that there was a program proposed for a child that were 5 boys and they were going to put in 1 girl. I don't think as a matter of law that I could say that, there has to be an equal number of students or there has to be at least 1 other girl. I think as a parent, as a guardian, that may be something that's important, maybe to your child because of her particular social skills, that would be important. I don't think there's a black letter law, though, that I could say in every case there has to be a balance or there has to be at least another child of the same gender. Okay. That being said, I'm not saying that in every case that it wouldn't be a problem either. I think you have to individualize it, to your child.
Okay. Someone else also happened to mention about the CPACs and getting advice from other parents, feeling that there almost needs to be a disclaimer that you're receiving information from other parents and not necessarily are those always based on the law or based on fact. They may be based on their particular experience, or sometimes there may be misunderstandings about what the law is. And I think that that's a great time if they have questions to contact somebody who does know the law.
Yeah, my suggestion with the CPACs is, those are generally parents within a school district who have had experience in the system, who have, I certainly can't comment statewide as to how qualified they are. I think there are some that would be extremely qualified. I think there are some, that may not have the experience and may not be capable. I think you have to, like anything else, I think you have to, measure the advice that you're getting and weigh it yourself. I use that just as an example of saying to people, you don't always have to run to someone and pay for advice. Sometimes if it's important, obviously I would hope as an attorney that I'm providing good advice and you're paying for that advice and I'm working hard to do the research and make sure that I tell you is right. You're going to pay for that, and I'm not suggesting that you should have to do that every time. If you're trying to figure out if your school district has a good program, for example, an after-school program, if you can find another parent who has a child who's been in that program, that child you would be far better asking that parent than you would me as a lawyer. So I'm just trying to suggest that you sort of be open to listening, but again, I think it's a good question. I think you have to assess what you're hearing. But I think the main thing is that recognize what you don't know and reach out, do your research to seek that information from others.
Great, thank you.
Effective parents maintain a cordial professional relationship with school staff. I think it's really important to remember that unless you're one of the very small percentage of parents who have your child go to an out-of-district placement, you're going to be in that school district for 12 years or more. I really do find that the parents who do the best have found a way to have a cordial professional relationship with that school staff. It does not mean, and please don't interpret what I'm saying as you have to go in there and roll over and not advocate for your child. I'm not saying that at all. Effective parents advocate, effective parents disagree. What I'm suggesting is that when you disagree, that you try to do so in a professional way. I work with school district attorneys all the time, and we disagree on behalf of our prospective clients, but we try to do so in a way that we both recognize that everything that we do is intended to be for a child. We're supposed to be working in the best interest of a child. You can have two very genuine people have opposite opinions, but it doesn't mean that you have to have an unprofessional relationship. So I think it's always worth it, to the extent that you can, to try to maintain that cordial relationship. Then we come to my, oops, excuse me, come back. We come to my biggest thorn in my side, email. Email causes very, very effective, very easy way to communicate, causes more problems than I can tell you. Because when you go home after a team meeting and you're angry and you've had a really bad time and you really want to voice your opinion about what happened, it's very, very easy to sit down there and hammer out, a very unprofessional email that perhaps says things that in reflection the next day you wish that you didn't say. But unfortunately, once you hit the send button, that email exists, and 2 years later, when you try to go to a due process hearing and I ask the school district for all of your students' records, all your child's records, that email is going to be right on top. And when I go in front of a hearing officer and I'm trying to present you as being a very reasonable parent, and you've got an email out there that you've said things that you wish that you didn't, you've used words that you wish you didn't, it's hard. So the advice that I give people is email's fine. I'm not saying don't use it. Write your email. If you're angry, go to bed, get up the next morning, read it again. If you're still not sure, send it to your mother. Ask your mother if she would be embarrassed if you sent it. And if you pass all of those tests, then go ahead and send it. And the same thing. I mean, we see parents who get, what I consider to be unprofessional emails sometimes from the school staff. When you get those, you put them aside, and when you come to see me, you point that out. And a hearing officer may be very well interested as to, why the communication has broken down. But I just think as a parent, it is certainly something you can control. I never see an advantage to an unprofessional email. You get nothing out of it. There's no reason to send it. So that's just a personal pet peeve. Next slide. Allow the school professionals the opportunity to do their job. Really important. When a school proposes a program, you have got to allow that school district to try that program in most circumstances. I'm certainly not saying if it's something that's unsafe, that's a different story. But I'm saying for the most part, if your school district, if your team proposes a program, you can certainly indicate in your IEP that you don't, in your IEP response, that you don't agree with it. But for the most part, I'm going to say to you, if they've proposed it and you don't try it, then it's going to be very difficult for me to convince a hearing officer that you need something else. So that being said, when they propose a program, let them do their job. If you try to micromanage it, if you, if you don't allow your child to do certain parts of that program, you're really giving the school district an excuse to say, well, the reason that it didn't work, parent, is because you didn't allow your child to participate. You didn't allow, your child to read at the reading level that we think that your child should have read at. So it's just it's a hard thing to do. Don't think that I don't understand how difficult it is when I tell you you have to try a program that you don't like. But unfortunately, we have to think short-term goals, long-term goals. Sometimes you have to try something in the short term before I can help you make to affect a long-term change. Effective parents build a team of professionals. Really important. This is special education when you get to the point where you're looking for significantly increased services or a different placement. It's virtually impossible for a parent to do that on their own. The Bureau of Special Ed Appeals really does rely upon outside professionals, neuropsychologists, educational consultants, speech and language therapists. We really need them to come in with you to tell, well, first of all, the team. I'm really jumping the gun. I mean, certainly you're going to be bringing those people to a team meeting, or you're going to be presenting their reports to a team. But if the team doesn't agree with their advice, you need these professionals on your side to go forward. You can come into my office and explain to me what your child needs, but the first thing I'm going to ask you, and I'm going to tell you you're probably right, but I'm going to ask you is, do we have a neuropsychologist? Do we have an expert who's going to support you with that? It really is, as I said in my slide, it is practically impossible to prevail in a due process hearing without expert testimony.
That kind of ties into one of the questions that someone has asked, is that in their experience sharing private evaluations with the school does not always lead to what they expect it to lead to. Many times the school will default to their own testing and not take the recommendations or the testing, outside testing, seriously.
Yeah, that's very, very common, and we'll hear it all the time. The school, I had a case 2 weeks ago where I don't know really what it is that they thought that they did, but they said, well, we reject the neuropsychological report. I don't really know what it means to reject it, other than I guess they weren't going to implement any of it. And as disappointing as that is to you as a parent, that you've gone to the expense and the time to bring this information to the team, and then they don't implement it. The reality is that the team, in all cases, is not going to be the final decision maker. If you have a very well-reasoned, well-written, well-considered report, and the team doesn't agree with it, then your next step, that's when you're going to be coming to an advocate, to an attorney, or be looking at a due process hearing to complain that your very qualified expert's report wasn't given due consideration. So despite the fact that you think that they may not consider it, that's not really a good reason not to bring it forward, because it doesn't end at the team level. I don't know if that helps. But
it does help. One of the questions that I would add into that is, do you think that a lot of parents want to present the report without necessarily having the evaluator present at the team meeting? Do you feel that it is more beneficial to pay that extra money to have them attend the team meeting?
It's hard to say in every case. So the question is, so you have this 35-page report written by a neuropsychologist, and you're going to be giving it to the team. You have a choice. You can ask the neuropsychologist to come to the team. Some neuropsychologists will call in by telephone, and they'll actually present their own report. Is it more persuasive? Sure it is, because you have someone with their qualifications that they're going to be talking their report. Is it mandatory? No, because the report speaks for itself. A good school psychologist should be able to read a neuropsychological report and speak to what your expert says. I don't think it's as effective, but again, I try to take into account that you're talking thousands, maybe $1,000 more to have someone, to prepare to be at to be at a team meeting. I think you have to weigh that. If sometimes you have a sense, sometimes I know with a parent going into a team meeting that the team is not likely to make any changes no matter what I present. In that case, I'm probably not going to waste the money to have the expert present.
Okay.
If I think that I really want to try to end it at this team meeting, I'm really interested in getting these services, if I think the team is going to be open to listen, then I would be much more likely to bring in the expert.
Okay, great.
Okay. So where do you get these professionals that I'm talking about? Very often, they're the professionals that you're working with. So if your child has a speech and language issue, your child may be receiving speech and language therapy. That person can be your consultant. Sometimes if you have a child on the spectrum, may have a developmental pediatrician, that pediatrician could be your expert. Other times you need to reach beyond your providers, and that's when you're going to be looking for the private neuropsychologists, the private educational consultants. Where do you find them? You can certainly find them through your providers. Your pediatrician may know people. Every advocate, every attorney has experts that we work with, that we recommend to clients all of the time. And I think that's important. It's really critical for parents to understand, if you're going to pick an expert, and I'll keep picking our neuropsychologists, because that's the most common one that we see. It's really important that you ask the question in that first meeting, are you willing to speak to a team meeting, at a team meeting? Are you willing to testify at a due process hearing if I need you? If a neuropsychologist or any expert says that they're not, then my advice is look elsewhere, because the paper itself, although important, doesn't do the trick. If I go to a hearing, I need that live body that's going to be present. So I think any neuropsychologist or any expert who's going to be working with a child that has a disability, you want to make sure that they're willing, to go forward with you. Same reason if your experts are coming out of some of the hospitals, and we're very fortunate, in Massachusetts that we've got some of the best hospitals around, Children's, Mass General. They've got great clinicians there that will work with your children. Some of them will testify, some of them will go to a team meeting for you, others don't. Others that are affiliated with the hospitals really see themselves as clinicians and they really don't want to get involved in the process. So if that's the case, then again, I think you need to look elsewhere to make sure that you do have somebody who's going to follow you through the whole process. Number 8, effective parents recognize that change takes time and you implement a plan to make necessary changes. The parents that I feel like I disappoint the most every year are the ones that walk into my office in May and June and they tell me that they want a different placement for September. And it's not that I don't want to work with them, it's not that I'm not willing to try to move mountains to get them what they want, but the reality is that if we're into May and June and you haven't got the evaluations done, if there's no time to have a team meeting, there really is no probability or very little probability that I'm going to be able to get a new placement for your child by September. If I have to file for a hearing in May or June, the Bureau of Special Education Appeals is really not going to have an opening in which we're going to be able to get all the witnesses in time for you to get a decision by September. So I really, my favorite parents are the ones who come in September for the following year, because then we can really build that team, we can strategize, we can have productive team meetings, we can try to do all of these things without going to a hearing, that's the goal always, is to avoid going to a hearing. So you really do want to sit down with someone who understands the process very early in the process so that you can sort of plot things out and say, this is what we need to do this month, this is what we need to do next month, this is when we're going to do the observation. You don't want to be trying to do an observation the last week of June because what's going to happen? Your child's in a blow-up swimming pool out in the parking lot or something. You're not going to. Your child's not going to be in his regular program. You don't want to do an observation, the week before Christmas vacation. I mean, those are all things that someone who's experienced working in the field is going to help you plot out, what are the best dates to do this? How much time do we need, to get to a hearing, for example, in March? Or when do I have to give this to a team so they can consider it in time?
Speaking of that, we have somebody requesting a question about, would you recommend asking the school's expert to observe the child if the parent doesn't have a private expert to observe?
So by that, I think I understand you're saying, so if you have a school psychologist who's done an evaluation, would you ask the school psychologist to do an observation? I certainly think you can. I don't think it's a bad idea. This is my bias. My experience tells me that very often you see school evaluators don't make recommendations. They basically will write a summary of what they see, or they will summarize your child's evaluation, but very few are writing very concrete recommendations to make a change. Very often what we see is that they say, well, the team will consider our report and we'll discuss recommendations at the team meeting. That's a big difference between what you get with a private observer. A private observer is really going to come in and be doing more of a comparison of your child's neuropsych report, and then by application saying, okay, am I seeing that or am I not seeing that in the child's program, and then making the recommendations. I could really count on one hand the number of times that I've seen a school evaluator or a school observer say that the school program's not appropriate. It just doesn't happen that often, and it's just the reality that we deal with.
Do you see a benefit to parents doing the observation? I mean, we get that request a lot.
Yeah, a lot of times parents, naturally, it's your child, you would like to go in and see what's going on, but the reality is that no matter what you see during that observation, you can tell me, and you could testify to it at a hearing, but unfortunately you don't have the credentials to go in there and say this is the way that it should have been, or that, you know, Johnny's interaction with other kids was problematic for the following reasons, because you don't have, you know, the training to do that. I mean, for example, as I said, I've been doing this for, you know, going on 15 years. I probably read 500 observation reports. I can't do an observation. I could certainly walk in, I could probably see the things that my observers would see, but I don't have the qualifications or the credentials, even with my experience, to write a report saying this is what, you know, the child needs. So I'm not trying to discourage parents from going, but maybe you need another observation after that.
Okay.
But you certainly have got to have someone with the credentials to make those types of recommendations.
And what are those credentials?
I think it depends on the nature of the of what you're looking at. So if you have a neuropsychologist, very obviously, you know, they're heavily credentialed. They're going to, frankly, do some of the stronger observations because they can comment on the academics, the social, the behavioral, the emotional. Sometimes we use educational consultants, for example, that have expertise in reading. So that person really couldn't come out and say the child's social program's not appropriate because she's not trained for that. But she could say that the Orton Gillingham or the Wilson reading program wasn't being delivered in accordance with standards, or, you know, something like that. Or if you had I keep going back to my speech and language therapist or an OT, they're going to make observations based upon their own level, areas of expertise, but they can't stray outside of that expertise. So does that make sense?
Yes, absolutely.
Effective parents think strategically. So I put that in terms of a couple things that come up pretty commonly in my practice. Question is, should you provide private services? So the typical example of that is the child in second grade who the parents have noticed is really struggling with reading, and they've tried to work with the school to get reading services, and maybe they haven't been very successful. So they do what parents can do for their children, and they go out and they hire a private reading consultant or a reading tutor to come in and work with your child. You're doing the best that you can for your child, and I credit you every single time. I credit every parent who does that. The reality, though, is that at the end of the year, when we sit down and we do assessments of your child, and your child has made all of this progress, and then you say to me, I don't want to keep the reading, I don't want to keep the tutor any longer next year, I want the school to provide the tutoring. The problem is that your child has now made so much progress that on paper, he or she may not look like she needs that level of tutoring any longer, and there's frankly no way to say that your child's progress was only made because of the tutor. The school district is certainly going to take credit for your child's growth. They're going to say your child doesn't need it. So it really kind of is a quandary. It's the question that I hate the most when parents say to me as an attorney, should I continue to provide private services for my child? Because, you know, again, as I said earlier, it's all about the child. We want the child to learn to read. If you have the means and the ability to do it, I'm not going to criticize you for doing it. But on the other hand, if you then ask me to get the school to provide increased services, it's going to become much more difficult. So it's really something that as a parent, I can't give you the answer. I can tell you the pros, the cons of each decision, but it's a difficult call. Think strategically, document your communications with the district. You want to make sure that if you're telling the school district something about your child's disability, it could be something as profound as my child has a disability, or you know, if there are certain timelines that are supposed to be met, and if the school district hasn't met those timelines, what do you do to document it? You send an email, you write a letter, you do whatever it is you're going to do to document that this problem has occurred. Give the school an opportunity to respond, because when you come to see me 6 months later, and you tell me that this has happened, but you tell me you told the teacher this on the playground, I don't have a record of it. And I'm going to guess that more times than not, if we go forward, the school is going to say that they don't remember you here, they never heard that before, they don't know that. So you really want to take the time to, again, remember what I said earlier about the emails, in a very cordial, professional way, you want to document the important things that your school district needs to know. So put it in writing. If it's important, put it in writing. If you want the school district to evaluate your child, don't ask on the playground. Send a letter, send an email that says, I'm noticing this difficulty with my child. Would you please conduct an evaluation? That writing is going to trigger all sorts of responsibilities and timelines that the school districts have. So you want to make sure, that you do that in writing. If you walk out of a team meeting and you had a teacher, for example, say, Susie's not making progress in my class, you may, if it's important, want to write an email back and say, I thank you for making the comment in the team meeting that Susie's not making progress, because that's going to be a record that was said. If she didn't say it, the expectation would be she would write back immediately and say, well, I never said that. That's not what I meant. So you just want to, again, and I'm not suggesting that every parent after every meeting needs to bombard everybody who is in the team meeting with emails. But you know your own child, you know the strength of your case, you know what's important. So if something like that happens, you want to document it.
Mm-hmm. We did have a question that I think before we move on that would be helpful. Someone is asking a little bit about the clarification between due process, mediation, benefits of each.
Sure. So that's actually an entire seminar that,
right.
that we do,
Exactly.
And I'll try to give you the 2 or 3 minute answer on that. When you work with a team, you work on anything in life, there's going to be, disputes. There's going to be disagreements as to what is best for a child. And again, as I said to you up front, I think 99% of the time, they are genuinely good faith disputes. The school district thinks that your child needs or doesn't need something, and you think that they do. So what do? You've maintained this cordial professional relationship, but you still can't break the deadlock. So under special education law, there's a couple ways to try to resolve it. The first one is really just informal. That's maybe you get an advocate at that point, or you get someone else to go with you, and you go back to the team. You enhance your presentation. You go to your child's provider, you go to the neuropsychologist, you bring in more information, and you try to convince the team on your own to see things your way. That's the easiest, that's the least expensive, that's the way that it's supposed to happen. If that doesn't work, then I think the next thing that can happen is mediation, and that's through the Bureau of Special Ed Appeals as well. There are assigned mediators throughout the states that work in each school district, and you and the school district can go to the mediation and work with the assistance of a trained mediator who's going to not impose a decision on you, and that's really important. The mediator is not going to make a decision and tell you what you have to do, but the mediator is going to work with both sides to try to get you to come up with some sort of a compromise that's going to be satisfactory, to you as a parent. It can be very productive. You don't have to be represented by an attorney. In fact, I don't do very many mediations. I try to stay out of the mediations and let it be as cost effective for the parent as we can. But you want to make sure that you have the ability, however you assess your own ability to advocate for your child, make sure that you have the ability to organize, put together a case, have the documents organized, put together a good presentation on behalf of your child. If you think that that's something that's very difficult for you to do, you may want to bring an advocate. There's a lot of trained advocates out there that are very good at mediations. Make sure that whoever you choose has experience, doing mediations. Or again, you can certainly reach out to an attorney to help you in a mediation. But again, the important thing is that the mediation, you don't lose anything because no one can. There's no decision. The mediator will help you reach a compromise. If it's not something you like, you walk away. And then, sort of the atom bomb of special education is the due process hearing. That's when you really have reached an impasse with the school district, and it's a really important issue, and you decide that you're going to take your case to the Bureau of Special Ed Appeals to have a hearing officer make a decision as to whether you're correct or whether the team's correct. It's a longer process. It doesn't have to, again, involve an attorney. But it is really very much like a trial. There is, as I said, there's a hearing officer at the end of the table. You have to be able to, testify, cross-examine witnesses, present legal arguments. There are some advocates who will do it. Most attorneys, I can't imagine, if you're a special ed attorney, you should be able to do a hearing. So that's, and the difference is, out of a due process hearing, the finding is binding. So it's binding upon you and the school district. So if, for example, you are looking for an out-of-district placement and the hearing officer agrees with you, then the school district is going to have to fund that, and they also reimburse you for your attorney's fees. If they rule against you, then you're back in whatever program that the district proposed or whatever the hearing officer says that they should provide for your child. So in my mind, hearings are for the most significant issues. If, for example, if you're arguing about your child getting reading services 3 days a week and the school district wants to give it to you 2 days a week, you probably don't want to go, to a due process hearing, because, the expense, the emotion, the time that you're going to spend for something of 1 day is probably not worth it. If it's a matter of eligibility, if it's a matter of whether your child should get services at all, then that's a different story.
Or placement.
Or placement, certainly placements. Most of my due process hearings involve placements.
Great, thank you.
Any other questions before I go to that last slide? Or?
There is a question that was definitely brought up about, having an advocate can be expensive at times, depending on the rates of the particular advocates. And there are a couple of people who have mentioned that that's a challenge for them. Any recommendations? I mean, we certainly have the call center here at the Federation, where you can contact the call center and they can do referrals for advocates, who some of the advocates charge sliding scales. There are advocates, there are even seasoned advocates who will occasionally take pro bono cases. And that is something that you can take a look at. I also know that there's SPAN, the Special Education Advocacy Network, has a list of advocates, and you can contact them about possibility of doing some pro bono or sliding scale work. What would be some of your recommendations?
I mean, I think you hit the main ones.
Okay.
I mean, I think that, I think we're all in this field because we want to work with kids. And I mean, I take several pro bono cases a year as a matter of practice.
Don't all start calling them.
No, I mean, and when I take them, they're for very significant reasons. I mean, they are families that are truly needy, who have children that are really in a very dire circumstance. That, I mean, I probably wouldn't take a pro bono case for, can I get a couple more hours of reading? But it's really a child who's not getting any services. It's a child who's really been left behind. And I fully understand that the parents are working really hard to try to fix it and can't. And we'll do 2 or 3 a year, because they're meaningful. I want to make a change for that particular child. And I think most attorneys in this field do that. And I know that advocates do the same. I do. If I don't do pro bono, there are times that I will do a reduced fee, depending on, or I'll take payment over time. I mean, we all work with parents to try to help their kids. So that's really about all I can say. I mean, I know there's a lot of agencies out there, who do provide, either pro bono or whatever, and I think you named them.
And it never hurts to ask.
Never hurts to
think
ask.
even if people are advertising at a certain rate, does not necessarily mean that that's the expected rate, or that they're, depending on the circumstances, not willing to negotiate.
Exactly. Yep.
Definitely. There was also a question from a parent concerned about labeling and whether it is beneficial to have the child's diagnosis listed on the IEP.
I guess that's sort of I think it's a unique circumstance. I mean, depending on your own circumstances. I think from my perspective, certainly it helps. I mean, if your child is, for example, on the spectrum, your child has a reading disability, why do we have an IEP? Well, we have an IEP because we want the staff to be able to read it, to know what your child has. To know what your child's needs are. So I think if I had to weigh the negative aspect of labeling as opposed to if you don't provide all the information on the IEP, I think I would be very much inclined to say, it's supposed to be a private, document. I mean, private to the extent that no one sees it other than those with a need to know on your child's team. I think anyone with a need to know really should know what that diagnosis is. I mean, I think it's very hard to hold a school district or a teacher to a standard if they don't truly know what the underlying, disability is. Now, again, there may be certain circumstances, if your child had post-traumatic stress disorder because she was a victim of sexual assault, that's a different story. I mean, that I think is something that you're going to handle with a lot more sensitivity. So I think I don't want to give a specific answer to that. I think it really does depend upon your particular child, your particular child's needs. I mean, it comes up a lot of times too. People will say, in a neuropsych report, it might list the family history, and there may be a history of psychiatric illnesses or alcoholism or something like that, and do they want to give that to the team? And I think the answer to that is, for many times, no, we don't want to. So what can you do? You can talk to the special ed director and say, we're going to redact out this paragraph because it's something that the team doesn't need to know. Mm-hmm. So I mean, I certainly appreciate that there are certain things that are going to be very sensitive, and and you react to each of those. But I think as a general statement, you want the team to know what your child's diagnosis is.
Mm-hmm. Yeah, I do believe that anyone with the complex trauma, the details of what the trauma is not as important as the fact that the child does have trauma.
Exactly.
And looking at it in that light. We did have one other person who wanted to ask you to be a little bit more specific about your advice on whether to tell the school or not regarding the private tutoring, whether you should be telling the school about tutoring.
Yeah, if you're going to provide private tutoring, then we certainly want to let the school know that. For one very good reason, having nothing to do with litigation. It really is that if you have an Orton Gillingham, for example, I can use reading as the example, but if you're providing reading tutoring, you want that tutor to be able to coordinate with your child's teacher to make sure that they're not using two different methods and confusing your child, or that the teacher can build upon what the tutor, or vice versa, that the tutor can build upon what the teacher is providing. So I think I can't think of a circumstance where you wouldn't want to tell the school district that you're providing private tutoring. My comment was just that it's the impact of the result of private tutoring that is going to perhaps be problematic, because when your child makes that progress, it's very difficult to attribute the cause of it.
Right.
But absolutely, if you're going to do it, you certainly want to coordinate with your child's teacher and team.
Mm-hmm. And just one other question that we want to address is coming from actually an advocate who is asking, actually an advocate in training, who is asking about the acceptance of an IEP. Should they reject the IEP if they disagree with the placement, as opposed to recommending that they just reject the placement and accept what they agree with on the IEP?
Yeah, I very seldom, if ever, just do a straight rejection of an IEP or a placement. Generally what I do is the partial. So I'm going to accept virtually everything in the IEP, anything that I want, obviously I'm going to accept. The other parts I'm going to basically say we accept them because that's all that you're offering us. However, we don't believe that they're adequate. So that's what we're going to do on the IEP itself. And that doesn't have to be a 20-page document like I see out there. That can just be can be a 2 or 3 page, 1 page. Basically what you're saying is that we're going to allow you, remember what I said earlier, we're going to allow you to implement your program. However, you're on notice that we don't think he needs more. You're only giving us 3 reading sessions. We'll accept the 3, but we think he needs 5. So then when you come to the placement page, I would reject, if you're not happy with the placement, you always want to reject placement. Because if you've agreed to the placement and then you later go forward saying, well, I want out of district, they're going to say, well, you've accepted the placement for the last 3 years. So you can reject placement, but then again, right on there, we're rejecting placement because I believe my child needs a substantially separate language-based program and you don't have it. However, we're going to accept it because that's all you have.
Right.
Does that make sense?
Yes.
Okay.
I think so. Other points that you have, or?
I mean, I think I'm coming to the end. I mean, I think the last slide that I have is really, one is more of the morale booster. It's the effective parents keep their child's educational experience positive. That really comes to me out of a bunch of frustrating experiences in working with parents who are working so hard for their children that it somehow bleeds over to their kids themselves. And I think that that's always not a good thing, we put it that way. It's frustrating sometimes when I'm at school, which isn't that often, but I'll meet, the child, and the child will start talking about, their own disabilities, their own, and that what they're doing is they're saying things that they've heard at home. Mm-hmm. They're talking like an adult as to, their own struggles, or they'll talk negatively about a teacher because they've heard the parent, talking about the fact that the teacher's not doing this, or I've had children say to me, well, my tutor's not qualified. I know that that's not coming from the child, it's coming from the parent. And I think it's hard because it's something that you're fighting for, you're home every day, it's discussion over the supper table perhaps, but I think it's really important to, to try to keep your children out of this process. It's hard enough for us as adults not to have a 14-year-old. I get into fights at team meetings all the time when they want to bring in a 14-year-old girl who has social emotional difficulties and they want her to sit in the team meeting while we all talk about her. And I walk out of team meetings. I mean, I take the parents and we go home if that's what they want to do, because I think it's really, really critical. And I'm not someone who's saying children shouldn't learn to advocate for themselves. But there are times when we as adults need to be able to talk about a child's disability without the poor child sitting there and listening to people talk about them. So that's really what I'm talking about, is that, to the extent that you can, allow your child to have a positive educational experience while we're working in the background to make it better. So maybe that's the best way for me to end.
No, I think that's great, and I appreciate your time and all of your knowledge.
It's always a pleasure.
It's great having you here, and we appreciate that. And with that, we are done with our webinar. We look forward to seeing you next month, and thank you for joining us.
Thank you for the questions.